Hi everyone, my name is Dana Lingenfelser and I am here with my partner Madeline Light. And we are here to give you a presentation with some helpful tools to navigate the legal aspects of the community association space.
Good morning or good afternoon, everyone. As Dana said, we're excited to be here. One of the first things that we wanted to start out with is really just looking high level. So the purpose of our presentation is aimed at either people that are new to the community association space or even seasoned people that just need a little bit of a refresher. And as Dana and I are somewhat new to the community association space, we wanted to share with you some of the items that we've seen that are common, either misconceptions and some things that can help with best practices as you're dealing with your different communities. So the first place that we want to start is looking at the statutes that primarily govern community associations. There are federal laws that, of course, apply to community associations, but for purposes of this presentation, wanted to focus on the North Carolina statutes that primarily govern community associations. First and foremost is the North Carolina Nonprofit Corporation Act. That's found in Chapter 55A of the North Carolina General Statutes. And the North Carolina Nonprofit Act applies to all incorporated associations. And it's funny to think about that so many community associations, since they are incorporated, are what's considered a North Carolina nonprofit. The nuance here, though, is when you're talking about that with people is to remember that just because you're subject to the Nonprofit Corporation Act, that doesn't mean that as a community association, you don't pay taxes and you can't make any money. You can make money, you can certainly make a lot of money depending on the community, and you are subject to some tax exemptions under the North Carolina Nonprofit Act. The primary thing that governs under that act is the governance of the actual corporation. So sort of the first stopping point whenever you're looking at the statutes.
And so for the next stopping point when you're looking at statutes, we want to talk about the Planned Community Act. So the Planned Community Act as a whole is a statute that will automatically apply to those planned communities created on or after January 1st, 1999. So long as the community includes 21 or more lots and all lots aren't restricted to non-residential purposes. And that being said, there are some provisions in the Planned Community Act that we will mention later on in the presentation that also apply to planned communities created before that January 1st, 1999 date. And also for planned communities created before that date or planned communities with less than 21 lots or even those restricted exclusively to non-residential use, they can also elect to make the provisions of the Planned Community Act applicable. So as we'll sort of talk about later on, it's always a good practice to consult the declaration and any subsequent amendments to determine the applicability of the Planned Community Act, regardless of when the community was formed. And so the Planned Community Act is also often applicable to your communities. Under the Planned Community Act, planned community is defined pretty broadly. And just as a brief definition, it's the real estate with respect to which any person, by virtue of that person's ownership of a lot, is expressly obligated by a declaration to pay real property taxes, insurance, premiums, or other expenses to maintain, improve, or benefit other lots or other real estate in the declaration. So this is a big statute you'll often want to look out for. And there are some important provisions of the Planned Community Act we wanted to briefly mention. So generally amendments to the declaration can only be made by an affirmative vote or a written agreement signed by the lot owners to which at least 67% of the votes in the association are allocated. But again, be sure to check the governing documents, to figure out how the votes are allocated to that specific community, and to be mindful that the declaration can still provide an even larger vote requirement to amend that document. And under the Planned Community Act, the Property Owners Association is given fairly broad powers, including the right to adopt budgets, collect assessments, make contracts, regulate, manage, and maintain the common areas. But again, these provisions can be altered and the powers of the association might be expressly limited or even prohibited by the declaration or the articles of incorporation, which we'll talk about later on in the presentation. And the Planned Community Act does state that unless the declaration provides otherwise, there are certain procedures the association must follow for, say, fining members, suspension of privileges, and these would include some notice requirements, an opportunity for a hearing, and notice of decision. And then there are also important meeting requirements, which we're going to go into detail more later on in the presentation, but those are something to look out for when you're having board or association meetings. And then one big sticking point is that there is a larger voting requirement that you should look out for if the association is conveying or encumbering common elements. So that is one thing to look out for if you're trying to do that. And the Planned Community Act will also talk about how you need to maintain insurance with a minimum policy amount, but we strongly recommend consulting with an attorney when you make decisions regarding insurance so that you can understand both what's required of you under the Act and what may not be required, but it's likely a good idea based on experience.
Yeah, and those are all really important parts of the statute to look at. But like Dana reiterated, between the statute and then your governing documents, those are always going to be your first stop when you're tackling any community association question. The next two statutes that you'll see here on the presentation is the North Carolina Condominium Act, that's in Chapter 47C, and then the Unit Ownership Act, which is Chapter 47A. So the planned community, as Dana said, typically applies to what you're going to think of in your mind as single family homes or townhomes. The Condominium Act, the word is in the name. Here you're looking at condominiums. Same for the Unit Ownership Act. Those are also what we typically would think of as a condominium. Chapter 47C, so that first one applies to any condominiums that are created on or after October 1st of 1986. So Chapter 47 was 1999. Chapter 47 is 1986. For the Unit Ownership Act, if condominiums were created before that October 1st, 1986 date, the Chapter 47A applies if the declaration has subjected itself to that statute. So again, those are the primary statutes to look at. So I think that's helpful whenever you're either speaking with your communities or speaking with your attorney to sort of orienting yourself to, okay, where am I at as far as the statutes? And that's a good starting place again for looking at issues.
And so the next place you'll want to look, which we sort of alluded to previously, when you're trying to make decisions and figure out what powers you have, those sorts of things, you'll want to look at the hierarchy of governing documents and the governing documents that apply to your community. So while the statutes we have discussed already will set forth some baseline powers, restrictions, and duties, the specific governing documents for your community are going to expound on those considerations, and where allowed by the statutes, they might even alter some of those baseline considerations. So the main document you will want to look out for is the declaration. This is the controlling document. It's on the top of the pyramid, and it creates binding obligations upon the association and all present and future owners of the property within the planned community. So this is really going to be the main document you look at. A good way to think of this is that it's a contract between the homeowners association, the lot owners, and usually considering the declarant. And the purchasing of a lot in the community, you're agreeing to be bound by the terms of that contract. So when answering questions about the rights, powers, or duties of the association, this is going to be the first and best place to look. And it can only be altered by amendments that must be executed through a process that will be set forth in the declaration itself. And there are some considerations in the statute that will apply when it comes to amending the declaration. And those amendments are going to be recorded in the same county where the property lies. And so the documents you see below the declaration on the pyramid can expand on the considerations set forth in the declaration, otherwise fill in gaps. But where the terms of the declaration and any of the other documents conflict, the declaration will generally control. And then you'll see on the slide, we have an asterisk next to the declaration referencing plats. So a plat is another recorded document that's often referenced in the declaration, and the plat's going to provide a visual representation of the applicable plan community, including lot designations and locations, common area designation and locations, and the dimensions of each. And it may even include things like easements. And while the plat is a recorded document and it's important to visually show and label certain areas, the authority and the precedential value of the plat would really depend on the specific situation and the document that's referencing the plat. So for example, where it's referenced by the declaration may say the areas labeled as common area on the plat are common area as that term is used in the declaration. Then the designation on the plat would generally take precedent over contrary language found in, say, the bylaws. But the plats don't cleanly fit within this pyramid, and the precedential value would generally depend on that specific factual situation and the document referencing the plat. So the next place on the pyramid below the declaration, we have supplemental declarations. Supplemental declarations generally expand the community and add more lots or common areas. And sometimes this document might actually create more restrictions or obligations or easements on a portion of the community, or otherwise alter some terms in the declaration. And in that way, sometimes it might act as an amendment to the declaration. So you should be careful when you're looking at a supplemental declaration, not to just assume the document only added property to the community just because of the label. It may also alter the terms of the declaration, sort of acting as an amendment. And then you'll see the Articles of Incorporation. So the Articles of Incorporation is a document that establishes the association as a nonprofit corporation under the North Carolina Nonprofit Corporation Act, which Madeline talked about previously. And it establishes member ability to vote. Sometimes the document will also limit the association's rights or scope of power, but most of the time it'll vest the association with broad powers, or will state the association should have all powers that are set forth in the declaration. And then you'll see the bylaws, and the bylaws govern the association's internal affairs, including things like voting, elections, meetings, officers, committees. And while the bylaws may be recorded, oftentimes they will not be and will be kept internally within the association.
An important point there, Dana, is typically we see bylaws, sometimes they are recorded, but it's important to note that they're not required by statute, unlike the declaration, to be recorded in the county that the community or the condominium is in. And again, just because they're recorded, it doesn't, up their prestige, if you want to put it that way. It doesn't make it where it would have the same weight as the declaration. So again, declarations are recorded, bylaws don't have to be.
That's a great point. And when thinking about the pyramid, declaration and articles are listed higher when you think about it, because both have to be either recorded or filed. And all of the important rights, rules, and obligations really should be contained in the declaration or the Articles of Incorporation. But again, I do want to reiterate that if the terms of the bylaws conflict with the terms of the declaration are going to control. And next you'll see design guidelines. So the design guidelines are going to set forth architectural and design considerations when you're trying to develop within a community. And the authority of the guidelines might vary depending on the specific community, and how specific or general the guidelines are will really depend on what's in the declaration. As we talk about later, when the association attempts to create certain guidelines, you'll want to consult the declaration regarding the scope of the authority to do so. And then you'll see rules and regulations towards the bottom of the pyramid. These are generally going to be formulated by the executive board of the association, and they're going to establish rules, policies, and procedures for internal governance. They might also regulate things such as the common areas and the use of the common areas. But again, as we're going to talk about further in the presentation, the ability of the association to formulate these rules and regulations and the allowable scope of the same would be set forth in other documents mentioned above, such as the declaration. And at the very bottom, you'll see board resolutions. So a board resolution is really governing the board's internal procedures as well, and how the board's going to act among itself. So if the board decides the draft of minutes need to be submitted to other board members for review by a certain period of time, say within a week of the next board meeting, this would likely be set forward in a board resolution. And at the bottom of the pyramid, this is going to be the least binding and likely have the least authority of the governing and corporate documents.
Okay, so now we've talked about our two main stopping points. You know to look at the statutes and you know to look at your governing documents. The next three slides that Dana and I are going to go over are the things that we've encountered the most in the community association space, whether it's dealing with managers or boards of directors or even just members of the different communities. There's either some misconceptions about some of these items that we're going to talk about and or just common mistakes that either we've made or we've seen other communities make that we'd like to help you avoid that pitfall. So as you see on the slide, stay in your lane. And really the takeaway from this entire slide that I'm going to talk about is understanding the purpose of each of these items. So minutes, committees, and rules and regulations. And again, staying in your lane, understanding the scope of authority that you have. And also just as importantly, knowing what you cannot do or what you don't have the authority to do. So first and foremost is minutes. And the common pitfall that we see here is, whether it's minutes from a membership meeting or minutes from a board meeting, it's almost a transcription, like a verbatim, every single thing that was said in that meeting. And that is almost the exact opposite of what minutes should be. We have sort of a somewhat cheesy quote, but I think it's a good way to remember it. They're called minutes, not days, hours, or weeks. So keep it short and simple. The main things that should be in the minutes are the date, the names of the attendees, the primary action items that were taken, and the votes. You can add more detail, that's within the judgment of the person recording the minutes or the board as a whole. But the primary takeaway from minutes is to keep them very short. And that's not because you're trying to hide the ball. It's not because you're not trying to be transparent. But that is the purpose of minutes, is just to record the main actions, show who was in attendance, and that becomes part of the corporation's records. An important point on the don't make it a transcription. It shouldn't be a whole script of every single thing that was said by everybody. It's not only are they a part of the corporate record, but they're also discoverable. And so, thinking absolute worst case scenario, which is what we as attorneys are, pretty much trained to do, is if you put things in there that could get you in trouble, to say it plainly, those can be discovered very easily. So again, all that's required is to put the main points in there and keep a record of the actions that were taken. The next thing is committees, and this seems to be more common than I would have initially thought, is two either pitfalls. And the main ones that I've seen are either committees that are acting beyond the scope of what they can actually do. So for example, if your declaration provides that you can have, some people call it a covenant committee, a violations committee, or an adjudicatory panel, where what we've seen is the covenants committee. This is the group that on behalf of the board will hear violation hearings, make notices of decision, and then depending on the decision, the individual or the member can appeal it to the board. An example where that's an entirely permissible committee. But where you can get into trouble is if that committee is also the one that is going out and doing inspections or finding the violations. So if you think about it from an everyday perspective, the police aren't the same people that will hear you in court. Police, there's a judge, there's a separation in between. So just understanding that what a committee can do has to be limited in scope and they can't overlap on other things. The second area of concern with committees is there's what I like to consider two distinct types of committees. There's committees that can sort of help do some legwork, like looking into an issue, researching vendors, whether it's for landscaping or it's some type of social committee. Those are what I call other committees. So they're committees that aren't necessarily taking any action, but they can do some of the legwork and then make recommendations to the board. And then the board is the one who actually takes the action. The second type of committee is a committee of the board, where the board has delegated some of their authority to a specific committee. And an example of that would be one of those adjudicatory committees, where they are actually holding the hearings, making decisions, and taking action. The board would still have the utmost authority, but they can delegate some of those actions. So again, you have your other committees who aren't necessarily taking action, or your committees of the board. And the primary takeaway with either of those type of communities is the best way to outline that scope of authority, the best way to make sure people are staying in their lane is to establish a charter that the board would set forth, laying out exactly what the role of that committee is. So that's committees, and we've talked about minutes. Last thing is rules and regulations. If we're thinking about that pyramid again, the best way to describe this part is whatever authority is in your declaration regarding what rules and regulations the board can make, that's the whole sphere of the authority that you have. So an example here is if your declaration says that the board can make rules or regulations regarding the common area, then the board can make rules and regulations that concern the common area. If the declaration does not say anything about units, does not say anything about lots, making rules over those, the board can then not say a rule over a unit or a rule over a lot. Again, that would be an example of exceeding the scope of authority. Another example there is if the board can make restrictions on pets, and the only type of pets that you can have are dogs, cats, and common household pets. The board could not make a rule that's then more restrictive than what's in the declaration. So if you have a concern that some of the rules or regulations that you want to enforce are the ones that you want to adopt and then enforce as a board, make sure again first that you're looking at, okay, what's the bubble that I have in my declaration that we can even think about. If it's outside of that, it's not going to be enforceable, and if it's challenged by a member or an owner, you're going to be in a tough place. So those are the main things that I've found.
So continuing with some common mistakes and how to prevent them, I think one of the big questions is understanding what's your responsibility as an association. And it's important for board members and managers to consider the scope of your authority, if any, for the action you're about to take. It's always a good practice to reflect on the scope of your authority, but especially if you're newer to the community associations arena or newer to the specific community association you're dealing with. So as we sort of alluded to, every plan community will have different governing documents, and even the applicable statute may change from community to community. So even if an association clearly had authority to do something in one community, the next community just across the road might completely prohibit such action. And going deeper into the association's specific maintenance obligations, the Plan Community Act provides that except where the declaration states otherwise, the association is going to be responsible for maintaining, repairing, and replacing the common areas of the association. And the lot owner is responsible for maintaining and repairing his or her lot. And while this sounds simple enough, remember the declaration can provide otherwise. And we've seen declarations in the past where common areas that are adjacent to a certain lot were actually required to be maintained by that adjacent lot owner. And we've also seen declarations where the association is obligated to maintain something on a lot, such as landscaping. So ownership of an area is not necessarily an indicator of who has the maintenance responsibility, and it's really important to take a deep dive into those documents, especially the declaration, to determine where you have maintenance responsibility. And under the North Carolina Condominium Act, the condominium association is going to be responsible for maintaining the common elements except where the act provides otherwise in case of a casualty. And in condominiums, an issue often arises when community associations professionals aren't aware of how the governing documents designate the unit boundaries. So unit boundaries might end at the studs of a wall, or might end at the paint on the internal wall. And that distinction, although small, could mean the difference between whether a unit owner must repair the area or the association must repair it. So again, it's really important to understand how your documents lay out where the units are, where the lots are, and where the common areas are, and which areas are going to be maintained by which entities. And issues often arise, we see, where certain improvements or landscaping are located on or near the boundary lines between the lots and the common areas. So sometimes taking a deeper dive into the governing documents, you might actually then need to get a survey done to accurately determine who must maintain what. So it sometimes does take a deeper dive than even the documents to figure out who must maintain what. And another common area of conflict is where you have multiple associations involved in maintaining a community. So, for example, you might have smaller sub-associations within a larger master plan community. And in that case, you'd likely see one master declaration that governs the entire plan community with a master association given certain maintenance responsibilities. But each sub-community within the master community umbrella is going to have its own declaration and likely its own maintenance responsibility. So in these situations, it's a really good idea to consult with an attorney to determine how all of these applicable governing documents are going to overlap and allocate that maintenance responsibility. And just to reiterate, the importance of understanding your responsibilities under the governing documents and the statutes really can't be understated. If you're responsible for taking care of an area and you don't do it, there can be wide-ranging repercussions, such as lawsuits. You might need to increase assessments to make up for past neglect, which we know no one will be happy about, and insurance issues, to name a few. And just knowing your maintenance responsibilities will help you more accurately expect what to put in your budget, and the members of the association are going to appreciate you for doing that.
Yeah, no one will that extra assessment, especially if it's something that has been taken all along. Good point.
And so next we're going to talk about again, how you common mistakes and how to prevent them. But at this point in the presentation, I like to picture the part in the Princess Diaries movie where Mia Thermopolis is running across Queen Clarice Rinaldi's lawn because she's late for princess lessons, and someone comes over the loudspeaker and says, "Get off the grass." And unfortunately, in real life, the consequences of not having sufficient rights to be on a piece of property or to access that piece of property can be much more serious than someone simply yelling at you to get off the grass. So if the association owns all of the property affected by the actions they're taking, I want to go ahead and say you're likely in business, and what I'm talking about here shouldn't be an issue. But issues often arise where an association doesn't own the property, but is nevertheless responsible for maintenance, sort of as we previously discussed, or where the association must cross over or otherwise intrude into someone else's property to perform its maintenance responsibilities, even if the actual maintenance will be performed on its own property. And in these situations, you will most likely want to ensure you have an easement to perform the work. And sort of as a bit of a distinction and background, an easement's generally thought of as an interest in property that allows someone to use another person's land in order to be effective, and in order to really just use their land. And in order to be effective, it'll an express easement must be in writing and must be signed by the person giving the easement. And the person giving the easement we'll call the grantor. I will caveat that certain situations will arise where an easement might be created without a writing, but for purposes of this presentation, we're going to be focused on express easements, which must be in writing. And contrast this with a license, which is generally going to arise where a landowner gives oral permission to someone to use their land, and a license is just an authorization, but is not actually granting a property interest, unlike an easement, as I mentioned above. And depending on the plan community, the answer to whether or not you have a sufficient easement might be found in the declaration. So often the declaration is going to have an easement rights for the association to access or complete the work on areas under its maintenance responsibility. And a common misconception is that the association also needs the easement to otherwise be recorded separately in order for that to be effective. But here, an easement that gives the association these rights via the declaration is generally going to be sufficient so long as the scope of the easement includes the work you're proposing to do. And if the declaration doesn't give you sufficient easement, you're going to want to look and see if there is a deed of easement separately recorded in the county, or there's a possibility that the recorded plat will have a sufficiently descriptive easement. And if you don't already have an easement to do the work you're proposing, but that work will either be done on someone else's land or will require you to access someone else's land, generally you're going to want to try to obtain an easement rather than simply verbal landowner approval, sort of as I talked about earlier, the difference between those and how those will be perpetual if it's an easement, but a license is not going to be perpetual, and a license can usually be unilaterally extinguished by the grantor. And even when you have a sufficient easement, a recommended best practice when exercising your rights is to give some sort of advance notice. So prior notice might be required under the terms of the easement document, but even where it's not required, prior notice can go a long way in preventing issues in the future. And then finally, once you have determined you have sufficient easement rights to be on a piece of property, a common issue we see is exceeding the scope of that authority. Even when you have an easement, the granting document is going to describe the scope of your permission to be on that land and what you can do on that land. So the document may limit the time frame for exercising your rights, such as say during business hours, or might require you to only use that property for certain purposes. And if you exceed that scope, you could be considered trespassing. And this is why before you do maintenance work, it's really important to carefully consider what document gives you the right to access the property and the document scope.
So this next slide is really looking at actions that are taken by the board. Whenever the board is exercising any of its authority, the main takeaway that we always want to reiterate with boards is to keep it methodical, keep it consistent. Again, we've said it over and over, but always reference your governing documents to understand, what's the baseline of what you as the board should be doing and how you can take certain action. One thing, so that's the correct quote that's on the slide. Make sure that whatever action you're taking, that you're following the correct procedures. The caveat here is, especially for discretionary functions, you want to make sure that anytime you encounter a situation where you don't necessarily have to take a specific action, that you approach that action the same way. So an example here could be certain types of violations. If you have a violation that seems to consistently happen throughout your community, but with one homeowner, it happens all of the time. And then with another homeowner, it's the first time that it's ever happened. You may not reach the same conclusion on what you decide to do as far as either fining the individual or, if permitted, suspending their privileges for common areas. But just as long as you're approaching it the same way, you're following the due process procedures, you're sending the notice of violation, and you're doing that consistently, it's okay in your discretion as a board, you come to a different conclusion. So long as that that conclusion makes sense depending on the circumstances, and you followed the correct procedures. Where I've seen boards get into trouble is they're approached with almost identical situations, and they treat one completely differently than the other, and there's not really a basis for treating it differently. A good example of this is sometimes if you have like an ARC or an architectural review board, whatever your community calls it, and fences, that seems to be a big thing. The declaration allows you to make guidelines about fence height, material, all different types of things. And the architectural review committee approves one fence, and then a month or so later, someone submits an application for almost the identical fence, and it's rejected or it's not approved. That's okay. It doesn't have to be the same answer every time, even if it is almost identical or similar, but there does need to be some type of reason. There's case law out there specifically with regards to architectural review of if you're going to deny something, it can't be arbitrary and capricious. You have to give some type of reasoning or some type of guidance to the lot owner of why it was denied or what would be needed in order for the submission to be reconsidered. Again, the takeaway and the main point of this slide is just whenever you're presented with situations, make sure that you're following the correct procedures, which means that you've looked at your documents, you've talked to an attorney if you need to, or whatever professional is the appropriate person. And that, again, even if the result is different, you approached it the same.
So here on the slide, we've set forth some best practices for board meetings to help ensure you're both efficient with your time, but also acting in conformity with those commonly applicable statutes we mentioned previously. So under the Planned Community Act and the North Carolina Condominium Act, the frequency of the board meetings are going to be determined by the bylaws of the association. So it's a good idea, especially when you're a new board or in a new community, to refer to the bylaws for the frequency and the procedures. And some of the best practices we have on the slide, we just think are simple but effective suggestions to have a successful board meeting. So you should try to prepare an agenda and establish an ending time. This will help you establish some basic expectations for what's going to occur and how long it'll take. And the end time doesn't have to be a hard cutoff line, but for purposes here, it's just to establish and keep everyone on track and try to make sure the meeting is more efficient and productive. And hopefully this could prevent some late nights for you. And then you want to ensure you start the meeting on time. Really, this is just to be respectful of other people's time. Board members provide invaluable services, but it is important to remember they likely have other responsibilities going on. And it can be helpful to distribute the last board meeting minutes in advance of the upcoming meeting. You can avoid wasting time and ensure the executive board has time to consider and review the prior actions prior to approval of the minutes. And adopting meeting rules of conduct, it's always a good idea to set forth some meeting rules of conduct so everyone knows what to expect procedurally, and it can help prevent some unnecessary tangents and sidetracks, and can potentially limit room for disagreement in the future. So this might actually be through a board resolution where you adopt a meeting rule of conduct, and it might be in regards to something such as using respectful language or limitations on the required open member forum, which I'm going to talk about in a second. And then it's always good to plan to have the minutes available for review by the other board members within a specified period of time and stick to that plan. It's more efficient when you do things fresher, when everything's fresher on your mind, and it's more accurate to incorporate the changes if you have any. But I will iterate that once the minutes have been sent out, really the review should just be a review, and you shouldn't be making huge substantive changes unless there's clearly an error there. And just to reiterate, meeting minutes are called minutes for a reason, and you'll generally want to limit the minutes to the things that Madeline's talked about, rather than having a transcription of the entire meeting. And it's important to encourage participation from all of the board members. This can go a long way if there's a future disagreement that arises between board members, but The fiduciary duties of board members, specifically the duty of care, requires you to act with diligence as a board member. So every board member should be asking questions and participating and voting unless there's a valid reason to recuse yourself. And finally, a common issue we see with the board meetings is failing to give adequate time to the member forum as required by statute. So both the North Carolina Condominium Act and the Planned Community Act have provisions regarding member participation, and it applies retroactively to the older communities that are created prior to those statutes' cutoff dates. So the statutory language requires that the lot owners be provided an opportunity to attend an executive board meeting and speak to the executive board regarding their concerns at regular intervals. And in order to satisfy the statutory requirements, the member forum has to occur during the board meeting. So the minutes should reflect the meeting was opened, and somewhere in between the opening and the closing of the meeting, the member forum occurred. So if you set up a town hall meeting or informational meeting that happens outside of that opening and closing of the board meeting for the members to raise their concerns, these meetings aren't going to satisfy the statutory requirements of member participation in a board meeting. And this doesn't mean that lot owners have to be given unlimited time and opportunity to speak at the board meetings, or that they could speak at every meeting, but it simply means at regular intervals, they should be given time to speak and air their concerns. But the board can and should place reasonable restrictions on the member forum part of the board meeting. For example, it'd be helpful to have a sign-up sheet where you sign up in advance of the board meeting or at the very beginning of the board meeting if you'd like to speak. Or similarly, you can and should limit the number of speakers and the time each has to speak.
And to make one distinction about what Dana is talking about with the open member forum, the key language in the statute is at regular intervals. So unless your bylaws say that members have to be able to attend every single board meeting, you can have two different types of meetings. You can have this open or general session where there is the member forum, but you can also have a closed executive session. And what I have cautioned boards on is there's really core 4 items that you should discuss during a closed executive session. And by closed, I mean you're not having that open member forum, 30 minutes at the beginning or 30 minutes at the end. It is just board members that are attending. And if you needed, your attorney there or a certain committee member, those would be the only other attendees. And the 4 core are personnel matters, legal matters, contract negotiations, and if you're ever discussing fines or delinquencies. Those are items that are most appropriate for a closed session, especially the fines or delinquencies or any types of violations. Those should be discussed only among the board members. And the next thing that we wanted to talk about is there are ways that a board can take action outside of a meeting. Sometimes, and especially you've probably experienced it as board members or even managers that are assisting with emergency actions. Sometimes you got to take the action, then you don't have enough time to call a meeting. Because boards can't vote by proxy. So you can't have a board meeting and then if I'm a board member and I can't attend, I tell Dana, oh, Dana, you be my proxy and you go. And the reason for that is the statute allows for board members to attend meeting by any means. So you can attend, by video conference, what we're doing now, you can attend by phone, so long as everyone can simultaneously hear each other. So that's the reason that proxies aren't allowed for board members. But the way that you can take action without a meeting is what's called uniform written consent. And under the statute, what that requires is 2 things. Every single board member has to participate and every single board member has to agree. So exactly what the name says. Uniform, everybody has to have the same answer. Written, so it's either written on a piece of paper or email, which is typically what you see. And everybody has to agree. That's the consent part. So once you have those 2 things, that's the way you can take action outside of a meeting. And the reason that we bring that up as, a best practice or a common pitfall is people will vote by email, but they won't satisfy one of those requirements. Either someone didn't respond to the email thread or someone disagreed, and then they say, oh, well, we had a majority, we had 3 out of the 5 say yes, or 6 out of the 7, whatever it may be. But if that's the result, then you haven't satisfied the statutory requirements, and that action is void. It's voidable. So one of the best practices for that, again, is just remember, if you're going to do it by email, try and keep it all on the same thread. Make sure someone is confirming that everyone has responded and everyone has voted affirmatively for whatever action you want to take. And the best practice is to keep that email thread, and that becomes part of the record. And then at the next actual board meeting that you have, you can vote to ratify those actions that you took via written consent. So then that would be reflected in the minutes, and it's just an even harder way to show, not harder, a more concrete way to show that that action was taken and that action is enforceable.
And so we wanted to also talk briefly about membership meetings. So under the Planned Community Act and the North Carolina Condominium Act, a membership meeting must be held once a year, and it should be properly noticed between 10 and 60 days in advance of the meeting. This is also one of the provisions that retroactively applies to those communities created prior to the statutory cutoff dates. And generally at this annual meeting, the members will take actions such as ratifying the budget, electing the board, or maybe voting on an amendment to the declaration or bylaws. But really this meeting can include a wide variety of actions so long as proper notice is given of such actions prior to the meeting.
And the second type of meeting that can happen for membership meetings, you can also do this for a board meeting, but members can also call special meetings. Under the statute, special meetings can be called by typically the board, a majority of the board, the president, or where it gets tricky and the point that we want to highlight for you all is members can call this meeting. There's a percentage threshold for each of the communities of how many people have to sign a petition, how many members have to sign the petition saying that they want to hold a special meeting. It is, for planned communities, it's 10%, so 10% of the total votes in the association, and for condominiums, it's 20% of the total votes in the community. And they also, in that notice, it has to be delivered to the appropriate person within the community, typically that's the secretary, and it has to list the specific purpose for why they want to hold the meeting. And the reason that we point this out, whether it's the threshold requirement or something that comes across your desk as a board member, the secretary, or even if it's delivered to the manager. The reason that I want to highlight this is the statute does have a certain turnaround time. So typically if you get a special meeting request and all of the items from the statute are checked off, so they've gotten the 20%, you've listed the items correctly, and the members provide that to you, if they've checked off all of those marks, the statute requires that within 30 days of receipt of that petition, you have to hold that special meeting. So again, just caution here that if you receive something, even that looks like it, even if you know from just looking at it, this is not right, it's not, they didn't meet the thing, it's 5 people out of the 300 that signed it. Make sure to just take a look at it. Make sure to have an exact note of why it didn't satisfy, or in the reverse, you've got something that looks pretty close, make sure that you're keeping track of that 30-day time frame. And again, normally whenever you're getting a special meeting request from the members, it's typically for something that's not so great and can be a little bit of heartburn for the board, because typically it's trying to remove members, or it's they're upset about something. It's not always happy butterflies and unicorns if you get one of those special meeting notices. So apart from that heartburn already, don't add to the fact that you might be late on complying with it. And of course, we're always available and willing to help with those if you get anything that looks like that.
And we also wanted to have a little note here about informational or town hall meetings. So there might be some circumstances where the association will want to have one of these. For instance, if the board's considering taking a certain action and wanted to get an idea of where the members are at and whether there'd be any support for the action. But these informational meetings are not sufficient to replace the annual member meeting. And it's important to remember you cannot take official action at these meetings. So there is a distinction between these informational town hall meetings and the annual meeting that you're required to have.
And the last item that we wanted to talk about, and again, something very exciting, somewhat new, most of you probably already know about it, but this was one of the very few blessings from COVID. Is during COVID, one of the governor's orders allowed for membership meetings for nonprofit corporations and other corporations to be held virtually. Prior to this new law that was just passed, reflecting the governor's orders, House Bill 320, that went into effect in September of 2021. It allows for membership meetings to be held virtually. It allows members to vote virtually at those meetings, and it allows for electronic voting. So again, prior to this bill being passed, and again, this was a change to the North Carolina Nonprofit Corporation Act, that Chapter 55 that we've mentioned a few times. Prior to this act, the only way that you could vote as a member or you could take action as a member is if you're in person or by proxy. You did a written ballot, so where everything's mailed out, and then you check for or against and send it back in, or uniform written consent, which, as you all probably know, is almost impossible. 100% of the membership agreeing on something, not really going to ever be able to take action that way. But again, this new law does provide some more flexibility. What we would caution here is, unless your board has a way that you're already very comfortable with it, something that doesn't stress you out if you did want to use these electronic voting. The virtual, we're pretty much all accustomed to that, Zoom, GoToWebinar, any of those. I think most people are pretty comfortable with that. The electronic voting is where we have a little bit of pause for concern. And the only reason we have that there is you want to be able to make sure that all of those votes, just like you would if you're getting written ballots back in, are confirmed, they're from the person that they say they are, and there's a few statutory requirements under this new law that have to be met if you're doing electronic voting. Prior to us having this law passed, there's about 32 states across the United States that have already been doing this. So there are electronic voting vendors that are familiar with this process. So whatever it is, if you choose to utilize this very cool new method of voting and taking member action, just familiarize yourself with the requirements under the statute, and if needed, maybe look into using a vendor that could help you get that set up. So it's one less thing for you as the board or you as the community manager to worry about. So with that, I know we've gone over a lot and wanted to open it up if there's any questions from anyone.